Okay, ladies and gentlemen, we're going to call to order our 7:30 Board of Appeals hearing. This is a rescheduled hearing that was originally scheduled on March 13, rescheduled to March 19, 2018, upon the application of Copeland Properties Limited Partnership dated January 26, on file with the board for an amendment of the special permit dated January 15, 2013, in case number 2345, at the premises located at 1131-1139 Randolph Avenue, which is located in a Residence A zoning district. The January 25, 2013 special permit allowed certain business uses, in particular landscaping uses, to operate at the property subject to compliance with the conditions set forth therein. Condition number 4 of the special permit prohibits external operations from any business on the property prior to 8 p.m. The applicant seeks to amend condition number 4 so as to allow external operation by the applicant's landscaping tenants to commence at 7 o'clock a.m. on the basis that the modification of the start time will not substantially increase any detrimental or injurious effect of the buildings or uses on the neighborhood and is consistent with the intent of the bylaw. Section 4A of the bylaws provide that valid pre-existing non-conforming structures or uses therein may only be altered by special permit issued by the Board of Appeals after public hearing. All is set forth in the application on plans filed with the board and open to public inspection. My name is Jeff Mullen. I'm the acting chairman tonight. With me is Nicholas Gray to my right and Virginia Donahue King, both board members. What we have in the application is the notice that I just read. The application itself submitted by Attorney Edward Corcoran for Copeland Properties, a letter from Mr. Joseph Prondak noting a violation of the special permit condition based upon a review of the property, seeking to abate the violation, and failure to comply with this directive or file an appeal in accordance with Section 9D of the zoning bylaw may cause this office to seek compliance through a court of competent jurisdiction. This hearing results from that letter. Mr. Corcoran attached addendum summarizing the situation, and all of that is available on file, as well as a copy of the original permit, which was issued in 2013 and to which I referred earlier. Now, we received today a letter from John Lawton, who lives at 100 Hillside Street, Milton, Mass., which is, don't know if it's directly abutting the Copeland property, but it's certainly nearby the Copeland property. I'm going to read the letter for the record so that everybody, for millions at home who are watching and the few people in the audience who are here, can appreciate what the letter says. And I'm going to make a statement, and then we're going to decide how to proceed. This is upon the application of Copeland Properties Limited Partnership dated January 26. Dear members of the Board of Appeals, my name is John Lawton, resident of 100 Hillside Street, former co-president of the Hillside Neighborhood Association and direct abutter. So he is a direct abutter of the Copeland properties located at 1131 to 1139 Randolph Avenue. I'm writing to express my concerns regarding the application of the Copeland Properties Limited Partnership seeking to amend the January 25, 2013 special permit for the premises located at 1131 to 1139 Randolph Avenue to allow special uses, in particular landscaping uses, to operate at the property. The applicant is specifically requesting to amend condition number 4 to allow external operation by the applicant's landscaping tenants to commence at 7 a.m. Condition number 4 under the existing permit does not allow external operations from any business on the property prior to 8 a.m. First, I want to express my appreciation for all that the Copeland Foundation does for the town of Milton and for continuing to fulfill the charitable mission first begun by Mr. and Mrs. Copeland. The generosity of the foundation is unmatched within Milton and surrounding communities. My position is not necessarily in opposition of the applicant, but in the applicant's ability to monitor and manage their tenants' operation. The multiple landscaping tenants have begun operating in disregard of the existing condition number 4. I ask the Board of Appeals to not approve the request to change condition number 4 of the special permit for the following reasons. Number 1, The current multiple landscaping tenants of the Copeland property do not comply with the current 8:00 a.m. start time of condition number 4 of the special permit. There is no question that the current tenants start their business operations well before 8:00 a.m. The start times are regularly 6:15, 6:30, 6:40, 7, and 7:15 a.m. These start times vary from day to day and do not comply with the condition number 4 requirement. The landscaping tenants start their operations before 8:00 a.m. start time requirement consistently 6 out of 7 days a week and for 7 or 8 months of the year. This has been happening for the past 4 years. Number 2, during the morning starting times and during the day of the landscaping operations, there is on many days significant noise related to truck movement, engine startups, and raised voices of employees coordinating equipment movement and operations. Number 3, I have every reason to believe that granting a 7:00 a.m. start time will result in the landscaping tenants starting their daily operation at a time that is earlier than they do under the current permit. Granting a 7:00 start time will result in a 5:30 a.m., 5:45 a.m., 6:00 a.m. start times. Excuse me. My other concern regarding condition number 4 of the special permit is that the start time is consistent Sunday to Saturday. I would like the Board of Appeals to review the current start time and alter the Saturday and Sunday time to make it later than the Monday to Friday start time. I recommend a 9 a.m. or 10 a.m. start time for Saturdays and Sundays. I appreciate your attention to my position regarding this important issue and ask that you vote to not change condition number 4 of the Copeland Properties Limited Partnership Special Permit. Sincerely, John Lawton. Now, there's another letter. Do I have it?
Should be at the back of it.
Here it is. Is this it?
Yeah.
No, this is Sanatellis. Bear with me. Okay. So that letter is dated March 19, received by the board today. This letter, this email is from Christoph Van Riet. Christoph Van Riet. It was an email received Monday, March 12. I haven't seen this yet. But since I read the other one, I'll read this one too, okay? So everyone can, I'm getting to the point of all of this. Bear with me. To the Board of Appeals, I'm in receipt of your letter regarding the March 13 hearing on the application submitted by Copeland Properties Limited Partnership on January 26 for the request to commence external operation by landscaping applicants at 7 a.m. instead of 8 a.m. I would like to voice my opposition to this requested modification as it stands, on the grounds that the increased noise earlier in the morning will even more adversely affect the residential neighbors, especially in the weekends and holidays. Over the past year, there has been a substantial increased amount of noise from truck and other operations by the landscaping services at the facility, especially in the weekends. Last fall, we have observed more heavy machinery, wood chippers, truck lifting, and cargo moving around, noise in the weekends than in prior years. One particular issue that has caused a lot of nuisance is that there has been lawn mowing done of the large grass field on the property each time at 7 a.m. on Sunday mornings. This noise has woken up numerous family members at our house, and I have reached out to the commercial lawnmower, John Driscoll from Driscoll Landscaping, who I see is here, in writing to please start his lawn mowing there at a later time on Sunday morning. Subsequent to the letter with their request, the lawn was still mowed at 7 a.m. the subsequent week, and only after having called Driscoll Landscaping in October last year, lawn mowing started at 8 a.m. Sunday morning. Also last fall, similar to a year before, there has been excessive motorcycle noise in the back of the warehouse from recreation motorcycle idling and racing on a makeshift Parker track. This noise has been noticed at several occasions during the weekends. Given the airplane noise that we as Milton residents have to endure, especially with our location within the flight path going overhead, any additional noise from truck and machinery operations is intrusive, especially during summer months when airplane noise is already at higher levels. The current stipulations for the location since January 25, 2013 have called for an 8 a.m. start time and during the weekdays. This is understandable. However, on weekends and federal holidays, there needs to be special consideration to noise pollution. We respectfully request that the board review the application and do not offer a special permit for hours outside of current business hours, especially on weekends and federal holidays. Thank you for your consideration. Best regards, Christophe Van Riet. So, I think people have a sense of what's in the file, and I know that the applicant is here to make his presentation, but I need to make a disclosure, and that is that I'm personal friends with John Lawton. I actually met John Lawton in a hearing many years ago here when they had an application related to some property in that same neighborhood. In light of John Lawton's letter and the fact that the application is entirely about the issue about which John Lawton objects, I actually don't think that I can be an impartial board member. Disclose this to Mr. Corcoran before the hearing, and I've spoken with my colleagues. I'm going to have to withdraw as a member of the board for the purpose of this hearing and ask that this hearing be rescheduled with a new member who can bring that impartiality. It's fairly rare that this happens, but I think under the circumstances and in light of the facts as had been presented, about which I became aware about 3 o'clock this afternoon, I don't see another alternative where I can be fair to both the neighbors, the town, and the applicant. And I just don't think that I can be impartial in light of the objection that's been raised by my personal friend, John Lawton. It's really not a matter of debate because it's a matter that I have to reach on my own, and in light of the fact that I'm acting chairman, I'd like to ask the applicant for permission to extend this hearing, extend this hearing, and we've arranged for a replacement hearing or a substitute hearing to be marked up. And I apologize to people in advance, but there was no way of knowing that this was going to happen. We can postpone this hearing till Monday, March 26th.
1 week from tonight. Oh, no, yes,
March 26th,
yeah.
1 week from tonight, at 7:30 in the John Cronin Conference Room. So, I know that I said a lot, and I don't know that it's appropriate to take questions, but to set the record straight, this hearing, unless there's Mr. Corcoran, do you have an objection? No objection from the applicant. We're going to continue this hearing with a substitute board member for the chair, 1 week from tonight in the John Cronin Conference Room. Thank you for coming. Sorry, folks.
We're still hearing the other case.
We're not adjourned. Should I say that?
No, because we still have the second.
Okay, fine. We're going to tell the folks on TV that we're not adjourned. I'm sorry about that.
Okay.
Mary, I'm going to put my materials in here so that Frank can have them, okay? The ones that you sent to me.
Thanks.
Can you send him a calendar invite? Thank you. Just another minute. We're good to go. Okay. We are going to call to order the 7:45 hearing of the Board of Appeals upon the application of Jason Sanatellis dated January 24 on file with the board for an amendment and renewal of special permit number 2420 that was issued by the board on December 29, 2014. The applicant would like to amend condition number 1, which states that there will not be more than 2 deliveries of mulch to the premises during any week, Monday through Saturday, and no single delivery in excess of 80 yards of mulch may be made. The proposed amendment provides that there shall be no deliveries of mulch to the premises before 10 a.m., or not later than 4 p.m., and 3 deliveries shall be allowed per week with no single delivery of mulch in excess of 80 yards. The property is located in a Residence B zoning district at 1146 Randolph Avenue, Milton, and is operated as a business known as Eagle Farm on property owned by Sanatellis Randolph Ave Trust. All as set forth in the application on plans on file with the board. My name is Jeffrey Mullen. I'll be acting as your chairman tonight. With me is Nicholas Gray, to my right, Nicholas Gray, and to my left, Virginia Donahue King, both of whom are members of the Board of Appeals. I have in the file a one-sheet application signed by Mr. Sanatellis. Largely consistent with what I just read. The application seeks to renew the special permit number 2181, amended and restated on December 2014, and amends Section 1 to request 3 deliveries per week between the hours of 10 a.m. and 4 p.m. I also have a copy of the original special permit as issued in 2014. I see Mr. Sanatellis is with us. Welcome to the Board of Appeals. How may we help you? You have to speak into the microphone.
Section L.
Section, what did I say, Section
Section
1?
because it looks like an I.
It
Or
does look
section
like a
I, it's an
1.
I, It's an I. Not that
It is
bad.
Section L of the application.
Sorry,
Mis-
H-I.
Section I of
It's
the
an I,
application.
yeah.
that Mr. Sanatellis seeks to amend. I remember the application. Mr. Sanatellis.
Good evening, board members. Thank you for taking the time and seeing this tonight, and postponing it from last week with the snowstorm. Bear with me, I'm not much of a public speaker. I usually have, over the last couple times I've done this, I've had representation. After talking to the building inspector, it's pretty straightforward. I'm just asking to renew my current permit that expired the end of 2017. And also in doing so, if you could consider adjusting segment I. At this moment, we're allowed up to 2 deliveries of mulch to the premises, Monday through Saturday. I'm requesting if we could change that to 3 loads of mulch per week, and it wouldn't be every week, it's just to have that. Over the past couple of years, there was times that we had ran out of mulch, and because of the constraint, we had to seek picking up mulch at different venues to support our customer base. And the second change would be, if permitted, there was a restriction on the time of the deliveries not coming before 10:30 a.m., just asking for a 30-minute lapse to 10 a.m. And that being, after talking to the delivery truck drivers, they all try to come down with a load and then pick up another load and go back to the next destination. And that 30 minutes would help them picking up their loads. And that's basically why I'm here.
Okay, let me restate that, okay? So you're asking for 3 things. The first thing you're asking for is to renew the special permit that, it actually expired on January 30, not the end of the year.
Okay.
So, and you're seeking to extend it for another 4-year period?
The last time we did this was a 10-year period.
Yeah, but we issued a 2014 special permit that expired in 2018. Is that not 4 years?
That is, but that was, this
It was a
permit
continuation
was a
because you had some
continuation.
objections from the neighbors, as I recall.
We did have an issue.
Yeah,
But the original permit, which I think this is based on, was from 2008.
it was.
And then we had a minor, an issue back in 14. And then the permit got adjusted, and we talked about extending that from 10 years to that period, and I think we came up with, why don't we see how it goes, and we'll come back when the permit expired.
Okay. So you're asking for another 10-year permit that would run from March of 2018 to 2028, correct?
Correct.
Okay. And you're asking, the only other thing you're asking for is in paragraph I, instead of it saying there shall be no more than 2 deliveries of mulch to the premises during any week, Monday through Saturday, and no single delivery in excess of 80 yards of mulch may be made, there shall be no deliveries of mulch to the premises before 10:30 or later than 4 PM. You would change that paragraph to have, permit 3 deliveries of mulch, and the deliveries can't be before 10 o'clock, but not later than 4 PM. Is that right?
Correct.
Okay. So there's a slight amendment and an extension. Let me ask you, how are things going up there?
I thought, since we were last here, I thought things went well. Speaking with Inspector Prondyke, it seemed that things went well.
And the mulch that needs to get there, we'd like to get there by 10, where is it coming from?
New Hampshire?
Always New Hampshire?
They have 2 plants. I believe one is in Maine and one is in New Hampshire.
So
I
it's
think
coming
they-
from New Hampshire. How many yards of mulch are in that truck at a time?
Depending on the type of mulch, anywhere from 60 to 80 yards.
And they drop it off there, and then why is it that they want to get there at 10 as opposed to 10:30?
The reasoning they gave me was to be able to offload and drive to their next
Oh,
destination.
I see.
To pick up a backload, they call it. They thought that the 30 minutes would help.
yeah.
It's not imperative.
Do
It's
they
not-
come north on Randolph Avenue or south?
They come north. They
come from the split.
the expressway.
Yeah, okay. And how many times do you think during a year you would need 3 deliveries versus 2? Is there any way to get a sense of that?
It's, if I had to guess, or an educated guess would be probably 3 or 4 weeks out of that April, May, June timeframe. It all depends on the weather is a factor, when Easter lies. It could change things.
Okay.
If it's a rainy season, which we've had a number of them, those numbers go down quite a bit.
Okay. I'm going to hold further questions. Let me ask my colleagues if they've got any questions of Mr. Sanatellis.
No.
Okay, is there anything else you have to add, Jason?
sir.
Let me ask anybody in the audience if they have, like to speak in support of the application. You ask if there's anyone in the audience like to speak in opposition to the application. Yes, sir. Welcome to the board.
Sat in front of the board,
Indeed.
for this permit, and although it hasn't been perfect, it's been better. And, he's.
You have to tell us your name and
Joe
address.
Martinelli, 10 Eagle Road, direct to butter. And, although, like he said, it's been better, hasn't been perfect, we've kind of bit our tongue on a lot of it, but the mulch has been the number one issue that drove this whole thing. And I think when you hear one delivery coming in, you have to realize there's 25 going out. You know, and you already got 2 coming in, so you get 200 deliveries a month going out in the mulch season. That's trucks getting loaded, the dust, the banging. So you're talking about adding another 100 loads going out, because the average delivery is 3 or 4 yards. It's very impactful, very dusty, very noisy, and it isn't 3 or 4 a year. A big part of Jason's business is mulch, and he could do it off-site somewhere, and he knows it. And, you know, we're trying to cram this landscape business into a residential area, and he's had such good success. It's just really impactful on a residential neighborhood, and we've gone through this over and over. And like I said, you know, do they water the mulch when it comes off the truck? No. I don't call. Is there more on the ground than there usually is? No. They use mechanical stuff to put trees in the backyard. I bite my tongue. But it's a lot better than it was, because it was out of control. But to go back to where we were after all that negotiation and special permitting and everything else, I don't know why. You know, it's really impactful. I know I have some neighbors here, and they'll speak to it too. You know, and now we have trees in the backyard, we have pesticide and smells coming over, and it just keeps creeping back into a landscape business from being a farm stand. That's what it was when we bought there. 20 years ago, it was a farm, tomatoes and, you know, lettuce. And it's a full-blown landscape business, and it's very impactful on our quality of life. And to add in, like I said, another, you know, 100 loads of mulch going out. One load in sounds easy, even though that's impactful, because when the trucks unload, the dust comes up, the sheen comes up, there's no water on it, the noise, but it's the stuff going out. It's another 100 loads going out, and we're already got 200 going out. You know, it's just endless for a couple of months. And that's when you start getting outside. You know, you go outside, you're in your yard trying to get and it's boom, 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 bang, 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 and it goes on and on and on. And it's very impactful. But like I said, it's better than it was, but to go backwards, I mean, you know, it would benefit Jason, but it would definitely be detrimental to us and the neighbors, I think. You know, and I'm sure he could do it off-site. He's got a place across the street at the Pepsi plant, which you've just spoken to. He's got a bin over there that he runs his landscape. Put it over there. Don't put it in our backyard. You know, it's just, you wouldn't want it in your backyard, trust me. It's not a passive type of thing. It's very impactful. It starts early. My wife works till 5 in the morning. She's a nurse, and all of a sudden it's boom, boom, boom in the morning. Every morning in the summer, you got to keep your windows closed, and it's tough.
Thank you. Can I ask you one question?
Yes.
So I'm not following the 100 going out. If it's 3 to 4 yards going out and 80...
No, it's 100 a month. You know, if you're going to add 1 load a week.
Got it.
Okay.
Okay, thank you. So 80 times 4 divided by 4.
Yeah.
Something
Well,
like
you
that.
know, that's when I talk to the land, they say the average wholesale delivery is 3 to 4 yards somewhere in there.
Fair enough. Okay.
People don't get 10 yards a month, well, unless you got a big yard, I guess, but,
Okay.
thank you.
Thank you, Mr. Martinelli. Anybody else like to speak in opposition to the application as presented?
Well, it's not really an opposition. So hi, I'm Maggie Oldfield, and I reside at 237 Hillside. I'm a town meeting member from Precinct 9, and with my brother, I own Thea Nursery. One of the benefits of owning a local business is not only personally getting to know our customers and our community, but also becoming friends with our other professional business owners in town. Being an entrepreneur can be lonely at times, but stories of weather disasters, equipment failures, and even customer complaints exchanged at the rink or at the sandwich shop have a way of connecting us even as we compete for the same clients. I have the utmost respect for my fellow business owners, and I want to not only see each of us succeed individually, but collectively as an industry. I'm excited to watch our children grow our respective businesses if they so choose, just as our parents have watched us. However, I'm here to speak about my frustration with the selective enforcement practices and inconsistent decisions and determinations of the building inspector and, unfortunately, the Board of Appeals. In 2014, the Board of Appeals granted a special permit to Eagle Farm to operate a nursery farm stand and to sell agricultural crops, produce, and other nursery items and materials, including storage and delivery of bulk materials, including mulch, loam, stone, and other similar products. And this permit expired at the end of January. It is my understanding that if a special permit expires at the end of a specified period during which the decision granting the permit allowed the business to operate, and no application was submitted to renew the special permit prior to the expiration date, then one can no longer be able to operate as they would have if they had the special permit. The 2014 Eagle Farm special permit specifically states that it supersedes the 08 permit, which is declared to be of no further force and effect. It further states that if the applicant wishes to continue to use the property under the special permit, he must reapply within a time sufficient to extend it prior to the expiration. And unfortunately, that didn't happen. And I mention this because if this was Thayer Nursery, we all know that on February 1st, Joe Prondak would have been parked his car across the front of my entrance so as to prohibit even one customer from entering my parking lot. I'm wondering if Eagle Farm has received a cease and desist as of today. Have they been allowed to operate these past 6 weeks? And the answer is yes. I know this because the town has actually hired them as subcontractors to plow the streets of Milton. I only care, unfortunately, because it relates to me, and this is proof that selective enforcement practices occur every day under the watch of Joe Prondak. Since the permit has expired, the process before you now is for Eagle Farm to go through the permitting process from the beginning, then to install any mitigation measures that are required, similar in nature to the ones set by the planning board, and then to receive an occupancy permit from the building inspector. However, the 2014 conditions you imposed on Eagle Farm and the ones that you are here tonight looking to amend are actually invalid because they authorize by special permit a use that may be authorized only by a variance. I'm not sure if I need to read the land court's decision in the Coulter case, but I can summarize it, and I have a copy to submit. It says, and I quote, and it's a very long quote, it says, "There appears to be confusion by the parties, particularly the Milton Zoning Board of Appeals, as to whether certain uses require a special permit or a variance. The central issue of that case was to determine the validity of the landscaping business via a special permit. The bylaw does not define the term landscaping business. By Coulter's description, a landscaping business provides landscaping services such as lawn care and maintenance, grading, sodding, tree work, landscape design, and snow removal on other properties, and would also sell plants, loam, mulch, and firewood grown on or off the business premises. A landscaping business would need to store on its premises the vehicles and equipment needed to perform its services, such as pickup trucks, dump trucks, trailers, and snowplow equipment, as well as materials for its services, including mulch, loam, gravel, and sand. The bylaw authorizes neither as a use, as of right, nor by special permit, the operation of a landscaping business, or the selling and storing of mulch, loam, fertilizer, stone, pavers, stone dust, and gravel as part of such a business. Furthermore, the bylaws do not allow it as a use, as of right, or by special permit, the maintenance of a 40-foot dumpster. Therefore, these uses require variances. However, the ZBA erroneously authorized these uses by special permit. Therefore, I find the conditions of the special permit are invalid, as they are authorized by special permit uses that may be authorized only by a variance." End quote. So based on this decision, this board ruled as a matter of law that Thayer Nursery cannot use our property for landscaping purposes, including the storage and sale and delivery of mulch, loam, stone, pavers, and firewood. So how can you now allow Eagle Farm to store and sell bulk materials in a residential district, even when the court ruled that Coulter and Thayer Nursery could not? Additionally, you might hear arguments that location matters, and it does. It definitely is an easier path for any business located in one of our 3 commercial districts, but none of our Milton landscaping companies are. Our addresses may be different, but we're all located in residential neighborhoods. That Town Tree, the Hunts, Eagle Farm, A. Thomas, Don Driscoll are located on Randolph Ave, a busy state road, should not even enter any conversation, because the Blue Hill address did not offer Coulter Landscaping any protection. You issued him a cease and desist. And in your 2013 decision regarding Thayer Nursery, you took note of the different locations of Coulter and Thayer Nursery, and specifically wrote in your decision that location was, quote, "a distinction without a difference," end quote. You determined that we should be treated the same, no matter our location. I do not oppose the permit renewal or the increase in the amount of mulch at Eagle Farm. I have nothing but respect for Jason. In fact, I always look forward to seeing what he is doing. I think his farm stand looks great from the road. I think it's incredible. And our friendly competition has pushed all of us to be better. I just don't see how they don't have to go through the same permitting process that we had to go through with the planning board. The process and the precedent has already been established. Collectively, the town, from the building inspector, town council, planning board to you, you're spending way too much time and, quite frankly, way too much money on property by property special permit and zoning issues. The conditions you set forth in each permit are completely arbitrary, depending on the applicant and who their current neighbor is. These conditions are impossible to enforce and can favor one business over another. This business-by-business approach to permitting is not working for any of us. As taxpayers, as business owners, we should have uniform regulations worked out for us to follow. Why would any business want to open up shop in Milton not knowing the rules? Or worse, knowing that the rules differ depending on who is sitting at the head of the table. The town has put in place a well-defined set of rules for all landscapers and all nurseries to follow. Not only have they established a process with consistent regulations, they've argued and defended this process in Superior Court, in Land Court, in the Court of Appeals, and it even went to the Supreme Judicial Court. And during each of these steps, town council supported this bylaw and argued that this zoning was not considered spot zoning because the other nursery businesses in Milton would benefit from it. The time has come for them to do so. And when Eagle Farm takes advantage of this business use bylaw and goes through the planning board process, I'll be there to speak in favor of their application. And you may want to rubber stamp these special permits, but because you've already made previous determinations regarding similar businesses in the same industry, in the same residential neighborhoods, you just have to apply the laws consistently and equally to all. There have been many missteps along the way, and I think it's time now to correct things. Thank you for allowing me to speak.
You're going to give us that letter?
Might be my letter. Do you want the land court decision?
We can get that, but if you want to give it to me, that's fine. Thank you, Mrs. Oldfield, appreciate that. Okay, so we have the 2013 Land Court decision to which Mrs. Oldfield referred, and a copy of her letter, which we'll place in the file, provided members of the board, if they'd like to look at them. Let me ask if there's any, thank you, ask if there's anyone else who would like to speak in opposition to the application. Okay, hearing none. Mr. Sanatelli, do you have anything else you'd like to add?
I do not.
Okay. Members of the board?
Any questions?
Yeah, question, sure.
I don't think so.
Mrs. King?
No, I don't.
So, I think I want to speak to town council. You know, it would have been great to have heard this before. And I know people have come out, but we've had a lot of litigation on these issues and a lot of hearings involving Thayer Nursery in particular on, in various courts, arbitrations, mediations, land court, Superior Court, I guess the Supreme Court, I missed that, but perhaps I should have known that. I think I'm not too comfortable with making a ruling on this in light of the testimony, without consulting with town council, given that town council is going to need to defend the actions of the board. I'd like to get a ruling.
I think it's a good idea.
I'd like to get a ruling.
I do recall that the Coulter case was out when we considered this decision. I know that we reviewed it, and I believe at the time we decided that it did not apply for reasons that I can't now remember because it was 4 years ago and I haven't looked at the case since. But I know we considered it when we granted the special permit and rejected that argument, that it was not within the facts of the same, it was not.
And that may very well be.
That may be the case, but
Yeah.
I'm happy to
No,
ask
no,
town council the same thing.
it's a good point, Nick, and it may very well be the case, but we do have the bylaw
Yeah.
to address. I'm gonna ask, I don't like to do this, but this is the second time tonight, I'm gonna ask for this to be pushed off, and for the board to have an opportunity to speak with both the building inspector and town council, and I'll speak to Mr. Flynn myself, and then we'll reconvene and consider the merits of the application in open session. Does the applicant object to that?
Not at all.
Is there any objections from the audience? Yes, Mr. Driscoll.
I wonder if she has one for the Copeland property, if she has a letter about that. Wouldn't she be good to give you the letter?
Well, we pushed that hearing off.
I know, but
It-
you said you'd like.
We just say as a rule,
You said you'd like to get this before the meeting?
well, as a rule, for everyone listening at home, it's always better to know what you're walking into. I think that's true in life, and it's certainly true in the Board of Appeals when you're on television and you don't know what's going to be said. So, sure, but it's not required. We've never required that. But when something comes up of a significance of what we're dealing with, and we're talking about an ongoing concern in the town and an important consideration, sure, it's better to have it in advance. So for anybody listening here or in the audience who has something to take up with the Board of Appeals, I urge you to get it to Mrs. Fitzgerald, and she'll certainly make us aware of it. So it's a good point, Mr. Driscoll, thank you. I'm going to ask Mrs. Fitzgerald if you have an idea on, do you want to set a date now for a continuation of this hearing? And just give us sufficient time to be able to have Mr. Flynn consider this?
How long do you want?
I think maybe a couple of weeks would be good. Maybe 3 weeks. Mrs. King? Maybe John Lennon would be back by then.
dear.
It's been a long winter.
12, 17, 18,
This is April?
how far out you wanna go?
I could do the 18th.
What day of the week is
It's a Wednesday.
Wednesday.
Wednesday, April 18th?
My only question is April school vacation.
Oh,
Um,
No idea.
25th?
Of April?
Is that
I'm
vacation?
not sure. I know that two of my kids,
That is,
I just know that two of my kids are on vacation now, and I was supposed to be in San Diego, and I just, want to make sure I don't conflict with April's vacation. If we could do it either before, I don't know
How about the
dates.
25th? April 25th, would that work for you,
Sounds good.
Mr. Sanatellis?
Yes.
Yes.
I have a question. So, do we operate under the expired permit until then?
Well, that's a matter for Mr. Prondak, and that's one reason why I want to speak to Mr. Prondak, because there was testimony as to a cease and desist order. I don't know that there's been a complaint raised, but that's definitely an issue in the first instance for the building commissioner. But from the Board of Appeals perspective, that's how the operation will continue, and we don't have that issue in front of us right now.
I mean, it's not something I'm pushing for, it's just.
I understand,
just-
but that would be my interpretation of it. All right? Wednesday, April 25?
Yep.
All right, this hearing is continued
John
to
Cronin.
7:30 on Wednesday, April 25th in the John Cronin Conference Room. Thank you very much.
Thank you.
We are adjourned.